There we go. We're live now. Good afternoon, everybody. Welcome to our webinar this afternoon. Just as people are beginning to join us and sign in, I'll just sort of advise you a couple of housekeeping rules as we go along. Just to let everybody know that this afternoon's webinar is being recorded. So if there are any points that are discussed during the webinar that you don't fully get or can make notes of, you will be able to go back at a later date, because we will share the video link with you, and indeed, if there's anybody else that you think that there might be pertinent aspects of the webinar, you can share it with them as well. So as I say, that it is being recorded and it will be shared in a couple of days' time. So, warm welcome. My name is Chris Elias. I'm a relationship director with Thrings, and I'm going to be your host, and I would almost say compere for this afternoon, because it's a slightly different format that we're going to use today for previous webinars. Today's webinar is part of our Business Health Matters program, which is an information program that we've been running throughout the pandemic, and it's been designed to give a little bit more insight into a number of key aspects and topics that clients have raised during the pandemic, and indeed we've expanded it to cover other sort of important topics which we believe are very, very relevant and worth discussing. It's part of a series of events, and indeed I've got a number of webinars planned out over the next 12 months. Our next webinar will be on the 17th of November, and it will be focused on the agricultural sector and landed estates, etc. So if you'd like to join that as well, we'll be sending out an invite fairly shortly on that. That said, today's focus is going to be on private client related issues, particularly in terms of succession planning in wills and powers of attorney, but also the exciting topic of post-death disputes. So that's going to be an interesting one for everybody to pick up on. So we have three panel members who you can see in front of you, who I'll introduce briefly. First up, we have Gavin Smith. Big wave, Gavin. Yep, there we are. You can tell that one's Gavin. That's good. So Gavin specialises in succession planning as well as lifetime gifting, tax planning and trusts. He also supports clients with complex wills and inheritance matters, including cases where the Mental Capacity Act has to be considered. Second up, we have Karen Perugini. Ciao, Karen. Big wave from you as well. Thank you. Now, Karen specialises in supporting elderly people make decisions about their future. She guides clients through succession planning, particularly in arranging provisions to cover care costs and care fees, and also the legal frameworks around tax planning. Last but by no means least, we have Emily.
Chris.
Big wave from Emily as well. Thank you, Emily. Emily Proud. Now, Emily leads our contentious probate team, dealing with a wide range of disputes arising following death involving wills, trusts and estates. She also deals with complex legal issues surrounding powers of attorney and professional negligence. Now, this will be an interactive webinar. There'll be a couple of polls which I'll run throughout the course of the webinar, which I'd encourage you all to complete. I said fairly straightforward straw polls, but it certainly helps us to get a flavour of what your thoughts and actions have been in terms of the topics that we're going to be discussing today. There will also be the opportunity for question and answers. So there's a little Q&A box, hopefully at the bottom of your screen. So if there's any question that you'd like to raise with any of the panelists, please jot those down and we'll endeavour to cover those at the end of the formal session. And even if we don't, we'll endeavour to follow those up after the webinar on a personal basis. So if you do think of something, please jot it down and let us know. So in terms of timings, the webinar is down for an hour, but we would imagine that the formal part of the webinar will last about 30 minutes or so. I doubt it'll be much more than that. And after that, then we will have sort of a 15-minute slot where we can have Q&A. So, 3/4 an hour, I would have thought would be fine. So you'll certainly be ready and able to go and get your tea ready by 5 o'clock. So there's no need to worry about anything other than that. So, as I said, a slightly different format today. So we're going to do it as a sort of a scenario-based webinar. So if you're all sitting comfortably, this is about Jackanory time for when I was a little bit younger and getting home from school. So if you, as I say, if you're all sitting comfortably, I'll begin. Right. Let me introduce you to Joe Miller. He is in his early 50s with a wife and 2 adult children, Jerry and John. He has built up a successful family business, Miller and Son, producing parts for the aerospace industry. So I'm not sure how busy he's going to be at the minute, right? Jerry and John have shown an active interest in the business and hope one day to step into their dad's shoes. Joe has never really thought much about getting his affairs in order, but with the pandemic, his mind has turned to protecting his business and affairs following death. Joe wants to know whether he should be thinking about seeing his solicitor to prepare a will from him. Now, I think we all know what the answer to that question is going to be. But Gavin, what would your advice be to Joe?
Yeah, well, as you say, the short answer is yes. No surprises from a private client solicitor at a law firm that we'd encourage everyone to have a will and also to review it regularly as well, so that to ensure that it reflects their current wishes. If you don't have a will, the intestacy rules will govern what happens to your assets. So those rules, rather than you, will determine what happens if you don't have a will. So it's worth just mentioning the intestacy rules briefly. So what happens under them depends on who survives you, essentially, which family members, so parents, wife, husband, civil partner, kids. So in Joe's case, we know that he has a wife and 2 children. So if he were to die without a will, and if we assume that his estate, so the value of his assets less liabilities, exceeds 270,000, then his wife will inherit assets up to that value. His wife will also get personal possessions, and the remainder will be split half to Joe's wife and half to each of his children. And clearly that might not be what Joe wants. It's a sort of fragmentation, and it's, some thought would be needed as to which assets go to which individual. And in terms of Joe's business interests specifically, first of all, we need to establish the nature of the business. So is it a sole trader business? Is it a partnership? Is it a company? And the next step would be to check the terms of any partnership agreement. So we'd always encourage people who are partners in a partnership to have a partnership agreement, make sure that the terms are all set out, and that may include wording on succession itself. And likewise with a company, the articles of association and the shareholders agreement need to be checked. There may be restrictions in them as to what Joe can do with his interest in his business. So we need to check those constitutional documents. And just an example of one thing in particular where a company is involved is we need to check who can appoint further directors of a business. Where a major shareholder or a sole director dies, the articles ideally will allow the deceased's executors for the shares to vest in them, so that they can then register as shareholders with Companies House, and they would have power to appoint a new director to run the business.
Okay, cool. Okay, so then Joe decides that a will is a sensible idea and arranges an appointment with a solicitor to discuss the terms of his will. He talks through his assets and the value of the business, his future plans, and his desire to protect his wife if he died first, but ultimately leave his estate to his sons. After giving those instructions and having the draft will drawn up by his solicitor, our government announced another complete lockdown. This means that Joe is not able to see his solicitor to execute his will. So, Gavin, is there anything that can be done to ensure Joe's will is executed during a lockdown period? And who knows what might be coming as far as that's concerned?
Yeah, a good topical one. I think it's probably worth just going back a step first and sort of setting out what the legal requirements are generally to have a valid will. So you've got to be 18 years old or over. You need to make your will without any undue pressure or influence. And these are legal technical terms that obviously we'd be happy to advise on. The individual must be of sound mind. So that means they must have the requisite capacity to make a will. And they must follow the technical, formal, strict procedure set out in Section 9 of the Wills Act. And so just briefly on that, otherwise than in very limited circumstances, the will must be in writing. It must be signed by the testator, and the testator is the individual who's making the will, in the presence of two independent witnesses who are present at the same time, and then those two witnesses in the presence of the testator need to sign themselves. So quite wordy and complicated, and obviously it's a bit of a hand-holding exercise. And at the moment, the witnessing element is potentially a bit more tricky with social distancing and people safeguarding and sheltering and that kind of thing. So turning to the specific question, the government has passed temporary legislation in relation to the presence requirement that I've just mentioned in terms of Section 9 of the Wills Act. So that presence includes virtual presence by way of video conferencing or other visual transmission. And that legislation has effect from the 31st of January 2020. So it's backdated for anyone who has done a will since then, and it's due to take effect for the next 2 years. So the legislation goes to January 2022. And just briefly, if time allows, in terms of what needs to happen for the video witnessing to be effective, so the testator and his two witnesses must have a clear line of sight of each other, and the remote witnessing must be done in real time. So you can't pre-record and then sign at a later date. You need to make a recording of the whole process. So that's the testator signing, and then he or she will post the will to the witness or witnesses. And then the second element, where the witness signs during a video recording with the testator watching, needs to be videoed as well. So again, it's a fairly bit of a rigmarole, and our advice generally would be use this as a last resort, because of the potential pitfalls with it and technological problems and whatnot. We would say if you can do the normal, in inverted commas, witnessing, do that. But if you really can't, then this is an option.
I think that's good advice. That does sound a bit of a complicated process, doesn't it? Really, but anyway, right then, folks. Before we move on, I'm just going to run a quick poll, just in terms of out of interest, really, see who's got wills at the minute. So there we are. That's the first poll in progress there. So if all those attendees would like to have a go at completing that, that'll be fine. So then, going, Joe follows advice and gets his will executed in this way, but his solicitor's explanation as to capacity has made him think about his aunt, Joanne. She's in her 80s, lives alone. He speaks to her regularly, but in recent times, she's been getting a little confused, aren't we all? And he feels she needs more help. Joe wants to know if there's anything that can be done legally to assist his aunt with her fluctuating capacity.
Yeah, so I think that the question is getting at powers of attorney. And if Aunt Joanne has an enduring power of attorney, then it might be that the time has come to register that, for her attorneys to register that so that they can use it. If she hasn't got an enduring power of attorney, and it's worth noting that EPAs, as they're known, are still valid, albeit they can't be created now. They're the predecessor to what we have now, which is lasting powers of attorney, or LPAs. And it's probably worth noting at this stage as well that they aren't just for elderly Aunt Joanne, they're for anybody. And we would encourage anybody, no matter how young, provided they're over 18, to think about lasting powers of attorney without being negative. You never know when the proverbial bus is going to come along and hit you, whereby you survive, but you lose capacity to make decisions for yourself. So that aside, there are two types of LPA. One deals with finances and the other deals with health and care. And in order to put them in place, a prescribed form must be completed and signed in a strict way, and then the documents need to be registered with the Office of the Public Guardian before they can be used. And just finally, I think it's worth noting that in Joe's case, given his business interests, he might like to consider what's known as a business LPA, and that broadly is a finances LPA, whereby his business interests would be carved out. So he'd have two finances LPAs, one that deals with his business interests and one that deals with his personal financial interest. He might be happy for his wife to deal with the latter, but he might be better off appointing his business partner, say, to deal with the former. As with wills, you just need to make sure that's allowed under the constitutional document. So always important to check the partnership agreement or the articles of association.
Okay, that's lovely stuff. Cheers, Gavin. Right then, folks, I've ended the poll, and I'm just gonna share the results, which are quite interesting. So hopefully everybody can now see those results. And I'm quite surprising, I think, from a personal perspective, really, that there 64% of those people who have responded haven't got an up-to-date will, which I would have thought it would have been there were a lot more people that would have up-to-date wills. So certainly, team, plenty to go at from the private client's perspective there, I think. So that surprises me. But what I think is really interesting, really, is that in terms of our second question, we've got 4 people who have found the secret of eternal youth, which is marvelous. So you'll have to make yourselves known, because I'll need to chat with you, I think. But otherwise, people just perhaps not got round to it, or perhaps they don't think they're old enough. But as I say, hopefully, as you start to appreciate, very important topics. So thank you for that anyway. So right, I'll leave that, and I'm now going to launch another poll, which I think I'll probably know the answers to on this one, actually. But anyway, if I launch that now, and I think we are ready to move on to Karen. So Karen, you're in the hot seat, unmuted. Well done. Thank you very much. So then, when taking into account his personal and business assets, Joe realizes that on death, there's likely to be a fairly large inheritance tax liability, which he would rather avoid. Is there anything that Joe can do during his lifetime to minimize that potential tax liability?
Yes, there is. When it comes to considering inheritance tax and whether this will impact on an estate on death, it's a good idea just to know what the current rules are, so we know where we're coming from. I always caveat any advice I give by pointing out to clients that I can only advise on the rules as they stand at present. Taxation is something which is always under review, and after the difficulties the country has faced this year, it's quite possible that inheritance tax could be seen as one way to recoup some of the financial losses. According to recent statistics, in the 2017 to 2018 tax year, inheritance tax was only charged on 24,200 estates, but in the last tax year it raised 5.2 billion. So it is a great source of funds for the government. I think we're going to have to watch this space really to see what happens next. At one point, tax simplification was on the agenda, but I suspect that might not be top of the priority list at the moment with all the other issues that we've got going on. In any event, at present, inheritance tax comes into play for any individual whose total estate exceeds 325,000. This is known as the nil rate allowance. If you're survived by a spouse or a civil partner, there's no inheritance tax to pay as the spouse exemption applies. On their subsequent death, you can apply the nil rate allowance from the first spouse's estate, so that there's a nil rate allowance combined of 650,000 on the second death for a married couple. In addition, a few years ago, a residence nil rate allowance was introduced if you have direct descendants to leave your home to. Again, this can be transferred between spouses up to a total of 350,000, which is why you might recall having seen the headlines a few years ago saying that the allowance for a married couple is now $1 million. With most tax-related issues, the small print sets out certain restrictions to the application of this relief, and certainly it is limited where the value of the estate exceeds 2 million. So what you've got, broadly speaking, is that for couples who have assets over 2 million, or individuals who aren't married, or they don't have any children, one of the lower thresholds would apply and a charge to inheritance tax would occur. So inheritance tax is charged at 40% on the value of assets in excess of the threshold, which definitely makes it worth reviewing to see if you're in a position to take appropriate steps to reduce the value of your estate and therefore the liability to inheritance tax during your lifetime. Just as a side note, I would mention that the rate of inheritance tax can be reduced so that it's charged at 36% rather than 40% if in your will you leave 10% or more of your net estate to charity, and the gift to the charity itself is also exempt from inheritance tax. However, there are other things that you can do to reduce the final tax bill. Certain types of property benefit from relief from inheritance tax, the main ones being business property relief and agricultural property relief. Again, as is to be expected, certain conditions need to be met to qualify for this relief, and these are mainly related to the types of property that's owned and how long it has been owned for. With businesses, the type of work that is carried out is also relevant. For example, relief is not available if the business activities consist mainly in dealing in shares, land or buildings, or making or holding investments. The rules relating to farming practices are quite strict as well. So, in spite of the fact that Joe is married with children and part of his estate qualifies for business property relief, he's still facing a large inheritance tax bill. So what can he do? It is possible to make lifetime gifts in order to reduce the value of your estate, and provided the rules are followed, these are exempt for inheritance tax purposes. One exemption is where gifts are made as normal expenditure out of income. So the donor who is making the gift has to be left with sufficient income to maintain their usual standard of living, and you would have to be able to demonstrate a regular pattern of giving. So you would expect to see somebody paying the school fees for a grandchild, or paying policy premiums on a regular basis. You can also make small gifts to any one person of up to £250 during a tax year, and there are no inheritance tax implications of that. They would be exempt for inheritance tax purposes. You can give this amount to as many people as you like, as long as the total amount that each individual person receives does not exceed £250. Another way to give gifts is if they are made as a wedding or civil partnership present. And those sorts of gifts are exempt up to a certain amount depending on the relationship of the donor to the couple. So each parent can give £5,000, grandparents can give £2,500, and any other person can give £1,000. Finally, most people have heard of the annual exemption, where you're allowed to give away £3,000 a year without there being any inheritance tax implications. If you didn't give away £3,000 the previous year, you can carry forward that unused allowance, so that in one tax year you could be giving away £6,000, and there's no issue about that at all. Technically, you can give away as much as you like in any tax year, and provided you survive 7 years from the date of making the gift, there are no inheritance tax implications of this. These gifts are known as potentially exempt transfers, as they only become chargeable to inheritance tax if the donor fails to survive 7 years from the date of the gift. The value of the gift then uses up all or part of the donor's nil rate allowance, reducing the amount of the estate which is exempt from inheritance tax. Taper relief can also be applied to the amount of inheritance tax due if the donor survives at least 3 years from the date of the gift. When deciding what he wants to do, Joe needs to be aware that if he makes the gift, it has to be fully effective for the inheritance tax exemption to apply. He has to give away something without any strings attached. So if he was going to decide to sign his house over to the children, he couldn't then live there because that's known as a gift with a reservation of benefit. And unsurprisingly, the Inland Revenue don't like it when people do that. They don't allow that to happen because otherwise everybody would do it in order to avoid having to pay inheritance tax. So if you're going to give away something, it has to be a proper gift. If the donor retains a significant benefit or enjoyment in the property given away, it will remain part of their estate for the purposes of calculating inheritance tax. So the property has to be that it is enjoyed to the virtual exclusion of the donor to make sure the gift is effective. Other examples would be, for example, if you give away a car, you can still have occasional lifts in the car, but that's as far as it goes. And you could pay a social visit or stay temporarily in a house that's given away. But you need to be really clear about what you're doing with that gift to make sure you're not caught out by any of these rules. My advice that I usually give to clients is spend it, enjoy it while you can and make the most of it. But if you do intend to make gifts, or if Joe does want to make some gifts, he needs to be aware of these regulations, because you don't want to defeat the object of making the gift if the sole purpose is for tax planning reasons and find you haven't quite done what you needed to do to make sure that was going to work.
That's kind of a lot to think about there, certainly. Right, let me just share the results of the second poll that we run, and not surprisingly, really, bearing in mind where the information we had with wills, 85% of don't have any powers of attorney, and have probably not consider them, mainly because they don't feel there's any risk at present. I think it probably is certainly sort of an age thing that I've just done one, so I'd not thought about it over the years. But then until you realise if you did have an accident or something did happen to you, it comes more to the fore. But an interesting view there. Right, cool. Let's throw those away there. Right then. Where do we go? Right, so Karen, let's carry on then, Karen. So the pandemic has made Joe realise that life is short, and after having spent his adult life building up Miller & Son to the successful business it is today, he feels that now is the time to take a step back. However, before he has the chance to do so, Joe sadly dies suddenly from a heart attack. His widow phones his solicitor, who has been storing his original will and who advises her and her sons about the will. Can you tell us about the terms of Joe's will?
Yes, so Gavin touched on it briefly earlier. Joe's will appoints his wife and sons as executors of the estate, together with their solicitor, so that they have a professional advisor on board who can assist them with the probate process and sorting everything out. The terms of the will are that the shares in Miller & Sons are going to go to his sons. So because Miller & Sons was set up as a limited company and Joe owned unquoted shares in the company, they qualified for business property relief. So there is no charge to inheritance tax for the value of the shares. All of his other assets he's left to his wife. So the spouse exemption applies, which again means there's no charge to inheritance tax on his estate at all, which is the good news. The assets that were left to his wife are held in a life interest or interest in possession trust, which means that she's entitled to receive the income from these assets during her lifetime, but she doesn't own the assets outright. So the reason why Joe might have done this is to make sure that his wife can still benefit from the assets, but if, for example, she formed a new relationship with someone after his death and ended up wanting to give assets away or spending all the money, she can't do that because she doesn't actually own the assets. The example I often give when I'm trying to explain this to clients is, it's usually with the man, and I suggest he might have run off with the local barmaid, but in the interest of equality here, perhaps the young tennis coach has recently taken an interest in Joe's wife because she's a seemingly wealthy but lonely widow. That kind of scenario. You don't want all the hard-earned family wealth to be lost if somebody's head is turned after one of you's died. So Joe's wife only has the right to the use and enjoyment of the assets, which means that she can live in the house as normal and she receives income from Joe's investments, but she can't decide to cash his investments in and spend all the money on clothes and holidays and flash young men. Also, the other advantage, which we often find people doing these kinds of wills for, is if, as she gets older, the wife needs to go into residential care in the future, the assets can't be used to pay for her care because she doesn't own them herself. So in that way, Joe and his wife can be certain that there are going to be assets that are preserved for the next generation, and it won't all get used up in paying for care fees. When you're drafting a will incorporating these different types of trusts, it's possible to place different restrictions and limitations on the way the surviving spouse would benefit. So sometimes people put restrictions in to say if they remarry at that point, they can no longer benefit from the assets held in the trust. In Joe's case, he's left everything to his spouse for her benefit until she dies, regardless of how her circumstances may change in the future. He's also included some flexibility in the trust to allow the trustees to advance some of the assets to her outright if it's appropriate to do so. This is a really useful mechanism because nobody's got a crystal ball. We don't know when any of these events are going to happen. We don't know what the wife may or may not need in the future. And you don't want to find that you've left a situation that makes life hard for Joe's wife, because that's not what he was trying to do. He was trying to protect her and protect the family. So with this extra bit of flexibility in the trust, the trustees can ultimately make the decision about whether it's appropriate to advance funds for her. So that's why it's really important to choose your trustees wisely and make sure that they'll be able to work well together in terms of balancing the interests of the wife with those of Joe's sons, to make sure that the wife is all right during her lifetime, but there is still going to be something left for the sons. When the wife ultimately dies, the inheritance tax position would have to be reviewed, because it's likely that a charge would occur at that point. But if Joe's priority has been to protect his wife and protect his children as much as possible, then that's the best that he can have done here. So the good news is, because he took that important advice from his legal advisor to find out the possible issues about inheritance tax considerations and how best to protect everything, he can rest in peace knowing that those he wanted to benefit after his death are appropriately looked after.
Oh, good. No, but I think things are about to start getting interesting here. Joe's estate administration seems fairly straightforward until Jane comes onto the scene. Who's Jane? Well, let me introduce Jane. Jane is Joe's eldest child from his first marriage, and she's somewhat of a wild child. And Joe and his family have lost touch with her. In fact, he's not seen or heard from her for the last 15 years. She has read about Joe's death in the papers, and while she has no real relationship to speak of, she is his only daughter and fully expects Joe to have left her something in the will, along with her stepmother and stepbrother. So there's more. She's furious, and she wants to find out what's happened, as none of Joe's wealth has been left to her, and there's been no mention of her in Joe's will whatsoever. So Emily, can Jane do anything to challenge the will? She's his daughter, after all.
It's a good question, Chris.
I think
the first thing to say is that just because Jane is a family member, that doesn't automatically give her any right to her dad's estate. In England and Wales, we have what's called freedom of testamentary wishes, which essentially means that if you have a valid will, you can leave your estate to whoever you want to. So Joe could have, if he'd wanted to, left everything to the cats and dogs home in this scenario, and Jane would not have a claim there. That's quite in contrast to some other European countries, such as France, where it's the other way round, and essentially your estate passes to your family unless you elect to do otherwise. But here we can do what we want. So Joe was quite within his rights to cut Jane out of his will. So in terms of Jane's position, if she's disappointed about her father's will, she'll have to bring a legal challenge or a claim at court. And there are only limited circumstances that she can do that, I'm afraid. I'm going to run you through those challenges very quickly. It's quite a big area of law, so this is just a headline for each one, really, more than a detailed exposition. The first thing to say about her challenge is she can't challenge because she's upset or disappointed. I have lots and lots of clients come and say to me, oh, it's terribly upsetting, it's really unfair, there must be a right for me to bring a claim, and that's not correct at all. Our judges don't recognise disappointment or upset, unfortunately, as a reason to change the terms of a will. So she's got to leave her disappointment and upset behind and look at other legal routes to challenge matters. And there are 3 ways she can do that, Chris. I'm going to run you through those very quickly, if I may.
Yeah.
The first one would be if Joe's will was not formally valid. Gavin helpfully talked us through the conditions for executing a will in his segment. And very briefly, you'll remember that a will has to be in writing, has to be signed and dated in the presence of 2 independent people. Now, if any of those elements are not on the face of the will, that will's not a valid document. And sometimes you find where there's been homemade wills that one or other of those elements don't exist. For example, someone's forgot to date the will, or they've signed it but only in the presence of 1 person, not 2. So if that was the case, then Jane could say that will's not valid and she could challenge matters that way. It's quite an uncommon challenge these days because most wills are drawn up properly. But with our changing law around executing wills remotely, I think we might see more difficulties in terms of wills being executed properly, because as Gavin said earlier, it's quite convoluted to sign things, to witness things electronically, and there could be errors in there. So watch this space on that one. On our facts say that that's not a claim that Jane can bring. So moving on to the next sort of claim to see if she can bring that claim. And we need to look at Joe's capacity and understand whether Joe was of sound mind when he executed the will, because if he was not, again, that will is not valid at law. Into it, sort of alongside that claim, there's another sort of claim as well. If Joe was being influenced by someone else to execute his will in a certain way, if someone was putting pressure on him, and that again would mean the will was invalid. We're finding lots of cases like this these days because we're living in an aging population. People are living longer and sadly suffering from more kind of degenerative mental health conditions such as Alzheimer's and dementia. So we're finding more occurrences of wills being executed perhaps at a time when they ought not to have been. So those sorts of challenges are quite common. But thankfully, Chris, for us, Joe was fairly young when he got his will drawn up. He knew what he was doing.
So mind.
And he wasn't influenced by anyone to leave his estate in any way. So he, you know, that's not a challenge that Jane can look into either.
Right, okay.
So it's not looking good for Jane, is it, at the moment?
Well, I don't know. Apparently, after she's obtained some legal advice, she's decided to challenge her father's will by alleging a claim under the Inheritance Act. This has the impact of stopping the estate being administered whilst the claim is ongoing. And most importantly, from the business's perspective, stops the transfer of Joe's interest in the business to his sons. Joe's widows and sons want to know if there's anything that they can do to resolve the claim and allow the business to pass to John and Jerry as planned, and for the widow to deal with his personal assets.
Again, it's a good question, and one the family should really be considering, because most challenges to a will take around 18 months to 2 years to get before a final judge. So they take a long time, and all the while the claim is ongoing, the estate cannot be administered and the estate assets can't be dealt with in any way. You mentioned there, Chris, that Jane's bringing a claim under the Inheritance Act, and just briefly to put some context with that claim, that's essentially a claim by Jane as a child of Joe for reasonable financial provision from Joe's estate. It's different to the challenges to the will. The will is still valid, but she's essentially saying, I need some money from my father's estate because I need some financial provision. And under that claim, the courts have wide-ranging powers to look at her financial position and compare that to Joe's spouse and sons and decide if they should give some of Joe's wealth to Jane. So it's a different sort of claim. It's one based on needs, and Jane would need to present some financial need to persuade the court that she ought to have some of Joe's wealth there. Back to your question though, what can be done to speed things along to ensure the business can use its assets and to ensure the sons can get their hands on them. My advice to the family would be to think about potentially settling the claim with Jane. Now, I'm sure the family are going to say to me they don't want to settle. They never do. Why should Jane have anything from her father's estate when she never spoke to him? And the reason I would give to them for thinking about this is a commercial one, really, because whilst the claim is ongoing, the estate is held up. The business assets don't transfer to the two sons, so the business can't deal with those assets in any way. I can't use them as collateral, and they can't put the business plans into effect. And thirdly, it's going to cost an awful lot of money for them to fight the claim to the end and to go to a final hearing. So I always advocate looking at the cost of what you might pay Jane versus the benefits of what you might get by concluding matters quickly. And I'd be saying to the family, think about offering her a sum of money and try and get rid of her.
Do a deal.
Do a deal.
Okay.
Absolutely.
Fine then. Okay then. So the family collectively decide to offer Jane a sum of money to avoid a protracted dispute that could impact on the business, even though they feel she doesn't deserve it. They want to know what Joe could have done to prevent Jane of bringing a claim in the first place. Is there anything that can be done to
Not really, sadly. I mean, it's a question I get asked an awful lot, but those claims are there. And they're in law, so we can't get rid of the fact that you can bring a claim. What I say to people, though, is that from a practical perspective, I would always advocate that you make your wishes known, be that about your personal assets and where they go, or your business interests and where they're going to pass on to. Make those wishes known during your lifetime to your family, and also get those wishes drawn up in a will. If you're going to make a controversial decision like cutting out a family member, I would suggest that you think about explaining why you've done that in a side letter to your will, so that there's some context behind your decision. And perhaps, if you possibly can, break that news before you die, because then it's less of a shock. Because I find that the most shocking wills are the ones that cause the biggest disputes. If everyone knows what's going to happen, you're hopefully less likely to get a dispute post-death. The final thing that Joe could have thought about was perhaps not cutting Jane out completely from his estate. Had he thought about leaving her a small gift, she may have been less inclined to challenge matters. She may have been less upset. But equally, if he left a gift that was equivalent to what she might get if she brought a claim, then there's no impetus for her to bring that claim. She would just, a good lawyer will say, we're going to get that amount under the will anyway, there's no point challenging matters. Yeah. So it may be not something Joe would want to do, but I would suggest that he think about perhaps having left something to Jane that might have avoided this nasty situation. And
I suppose it shows as well that you've thought about that particular aspect as well, haven't you? And
absolutely,
you've addressed it rather than just leave,
absolutely,
not saying anything. So
absolutely. So, as I said, honesty is often the best policy in these sorts of things, as hard as it may be to talk about during lifetime. I think actually telling people what you're doing and making sure you record it properly is the best way forward, really.
Okay, thanks very much for that, Emily. That's wise words as ever. And thank all the panelists for some fairly, some quite large detail that they've scalloped through there, really. So, some very important points, which I'm sure they would be more than happy to pick up on personally if anybody has any queries. We do have a couple of, I'm just conscious of the time, we do have a couple of questions that have come through. One from Jan Deos. Perhaps this is one for Gavin for you to pick up. If one has a finance LPA, does that also cover the attorney to act on the business?
Yeah, I think there's two things. One is in terms of if you are a shareholder, then yes, generally there aren't restrictions on being able to appoint an attorney, obviously subject to anything in a shareholders agreement. And then the classic lawyer answer to the other sort of side of the fence is if we're talking about a director, directorship is a personal role that generally can't be delegated unless special provision is made in the Articles of Association. So it really does depend on what those Articles of Association say and whether they confer on the directors the ability to broadly delegate the vast majority of their powers, or whether they say that directors can only delegate to the extent of say voting at board meetings. So it's a classic lawyer answer is it really depends on what the Articles of Association say. So we need to have a look at them.
I think Jan has mentioned that it's a sole trader, Gavin. Does that have any further impact?
Yeah, that is helpful in the sense that sole trader less complicated in some respects. So broadly, it would probably be okay, but with the caveat that you know we'd have to have a look at the business itself.
Okay, fine. Thanks very much. We've got a couple of questions left here. One from Oliver Harwood. What can you put in a will trust? How does it work, and how does it offer savings? Who wants to pick that one up? Who's the volunteer? Karen?
Yeah, I'll take that one. So with a will trust, you can put in whatever assets you want to, essentially. The savings really come in when you're looking at that in the context of all of your other assets and what's going to happen when you die and who you need to look after and where inheritance tax comes into it. So it requires full review and careful thought, really, when setting up any kind of trust, whether that be in your lifetime or in your will, to make sure it's going to do the purpose that you want it to do, and to make sure you're not causing yourself further problems down the line when there are other taxation issues that come into play, because you need to get that right advice to make sure all aspects are covered.
Okay, thanks, Karen. Now there is one, I'm just conscious of the time, folks. There is one further question from Chris, but Chris, I sense it's perhaps a more in-depth question. So I think that's probably one which we will get back to you personally on that one, perhaps when we can spend a little bit more time answering it face to face rather than in a public domain. So we'll pick that up with you separately, Chris, if that's okay. Also, Jan, I think there are a couple of queries from your perspective as well. So again, if we'd like those to be picked up separately, we will certainly endeavour to do that. So, ladies and gentlemen, as I say, I'm just conscious of the time. You know, there's an awful lot which has been covered there, and you know, when you have a webinar like this, virtually all the points I guess which have been raised can be very relevant and personal to each and every one of us in terms of wills and powers of attorney and all sorts of things like that. So you know, it's a complex sector. So we've got the experts. If you do need to refer to it any time, please do pick up the phone, ask. We're more than happy to have a chat. Hope you found today's webinar very interesting. I've found it quite interesting and very interesting and thought-provoking. So thank you again, and have a very pleasant evening. Thank you to our panelists, much appreciated. Good evening, everyone. Bye.
Bye-bye.
Bye.